Members, the time for this debate has expired. The House now comes to consideration of the report of the Privileges Committee on a question of privilege concerning the defamation action Attorney General Ngao versus Lee.
Mr. Speaker.
I call the Honourable Minister Chris Finlayson.
Mr. Speaker, I move that this House take note of the report of the Privileges Committee on a question of privilege concerning the defamation action Attorney General Ngao and Lee. Mr. Speaker, this is a very important piece of work which has been undertaken by the Privileges Committee since September 2012. We finally reported to the House just a few days ago, and it raises some very important questions arising out of a decision of the Supreme Court in September 2011. Throughout this debate, we're going to hear comments about parliamentary privilege, but it's important to emphasise what this word privilege means and what it does not mean. Parliamentary privilege is not there as a special benefit for a particular person. Parliamentary privilege is there to enable this Parliament to conduct its functions. It is vitally important for New Zealand's constitutional health. And I sometimes think it's unfortunate that this term privilege is used, because it does have a connotation of it's for the benefit of the individual. Far from it. Just as legal professional privilege is there to enable clients to be upfront with their lawyers so that lawyers can properly represent them. But the idea of a privilege contains the connotation of some kind of favour, and this committee and this Parliament is not concerned with parliamentary privilege in that kind of characterisation. It's concerned with privilege to enable this place to run properly in the interests of the New Zealand democracy. Another term that's going to come up in the course of this report is what exactly is a proceeding in Parliament. And I think for too long there has been vagueness about the metes and bounds of what is a parliamentary proceeding. And we say in this report that the time has come for a parliamentary privilege piece of legislation that addresses that particular question. So they are the high-level issues that were confronted by the Privileges Committee as it undertook its task, as I said, between September 2011 and 2012 and June of this year. The background to the proceeding, which ultimately went to the Supreme Court, is set out in the report of the Privileges Committee, pages 8 and 9, and I don't need to go through it in any length. Most members know the background, that Ms. Lee was contracted by the Ministry for the Environment as a communications advisor on climate change issues, and in 2006 she was told that another communications expert, a certain Claire Curran, was going to be appointed to oversee the strategy on which Erin Lee was working. There were a number of questions in the House concerning these appointments. Mr. Gao from the Ministry for the Environment would have gone across to the Beehive office of the then Minister for the Environment, given that particular minister a written briefing and orally taken him through the particular issues, and he gave answers in the House. In due course he apologised for some of the statements he made, but in any event the critical issue here is that proceedings were commenced by Erin Lee against the Attorney General in respect of the Ministry for the Environment and against Mr. Gao, the public servant, alleging that the statements that were made in the House constituted a republication of the statements that he had given to the particular minister. Then there was what could be called interlocutory warfare for a number of years. There was an application to strike out parts of the statement of claim. Eventually it found its way to the Court of Appeal, which dismissed the appeal of the Attorney General and concluded that statements made by an official to a minister for the purposes of replying to questions for oral answer were not themselves parliamentary proceedings. And so that very critical issue of what is a parliamentary proceeding arose. The court rejected the submissions of counsel for the Speaker, John Pike, that the proper test was whether the occasion in question was reasonably incidental to the discharge of the business of the House, and they also disagreed with some statements made by David McGee, then Clerk of the House, in his book about the nature of the particular privilege, and they preferred to rely on the basis of necessity as being an essential underpinning for parliamentary privilege in New Zealand. And with the greatest respect, what I think they did was they referred to some of the cases on barristers' immunity and public interest immunity and so on, which have been pared back over the years, and they've simply applied a test of necessity to parliamentary privilege. And as a result of this very important, albeit interlocutory decision, the Speaker indicated that he wanted the Privileges Committee of Parliament to look at the issue and provide some advice to the House, and that is exactly what we did. I think the process undertaken by the committee was exemplary. I particularly want to recognise the Deputy Clerk of the House and Catherine Parkin, the Clerk of the Committee, for the excellent work that they did in assisting the committee. We wrote not only to a number of legal experts in New Zealand, like the President of the Law Commission, Sir Grant Hammond. We spoke to Professor Philip Joseph. We also spoke to the State Services Commission. And I think as a result of that got a pretty good idea of where we needed to go. Importantly also, we undertook some inquiries overseas, and we were very grateful to receive advice from the Committee of Privileges in the Australian Senate and the Committee of Privileges and Members' Interests in the Australian House of Representatives, the United Kingdom House of Commons. I think we had some answers from Canada, and all in all, the comments that and the advice we received was very helpful indeed. And so, as I say, the committee met, and it has decided, Mr. Speaker, that the time has come, and the conclusions are set out in the report itself. The time has come for Parliament to bite the bullet and pass parliamentary privilege legislation that addresses some of these questions that frankly have hung around for too long. What exactly is parliamentary privilege? What exactly is a proceeding in Parliament? And if we can address these questions, then I think we will be doing this institution a big favour. It's not as though the issue hasn't been on the agenda for many years. I know that David Cagle, when he was in opposition, went to the time and trouble of preparing a draft bill on the subject, but it went no further. The Privileges Committee has looked at this issue from time to time, but, Mr. Speaker, the time has come, I believe, for Parliament to deal with this matter once and for all, and we say that the Australian legislation of 1987 provides a good model. In conclusion, let me say this. I saw today that the New Zealand Herald had said that we're striking back at the Supreme Court. No, we're not. We're recognising that as between the various branches of government, there has to be comity. We have to show respect for the court system, which is why there are very stringent rules on the sub judice rule and matters such as that. But likewise, we say that it's a two-way street, and the committee respectfully says that on this occasion we think that the courts have got it wrong. They have misinterpreted what exactly parliamentary privilege is all about. It's a hugely important question, not for individual members of Parliament, but for the institution and ultimately for the parliamentary democracy in which we work and live. So, Mr. Speaker, may I conclude once again by thanking the officials, thanking my colleagues on the committee for what I think is a very important report.
I call the Honourable David Parker.
Thank you, Mr. Speaker. Can I begin by thanking